A distinct legal jurisdiction for Wales is a limited legal change with significant practical advantages. Just to be clear, I'm not arguing for the complete separation of courts and of judges. This isn't a question about buildings or about people, or the colour of the robes or the crest above the chamber. In fact, there will be significant advantages for litigants and for the public if the legal personnel, be they judges or practitioners, are the same individuals operating seamlessly in parallel jurisdictions of Wales and of England. It's not at all unusual in our common law tradition for lawyers to be dual qualified in this way, so this is not an innovation. But with an expanding body of Wales-only law, coupled with a distinct geography, it would seem common sense, let alone legally attractive, for this to be accompanied by a rule that the laws passed by this body affect only devolved Welsh laws and do not affect English law, otherwise known to all intents and purposes as a distinct Welsh jurisdiction. This is a pragmatic change, and it will have a positive effect of helping to avoid some of the border skirmishes, if you like, which are otherwise inevitable in drafting the law and in operating it. But there's another issue to be considered as well. In the common law tradition to which we in Wales and England belong, judges are bound by precedent when interpreting the law. They're bound to follow the decisions of judges of higher courts in the same jurisdiction. With a single legal jurisdiction, precedent created in an English court on a matter which in Wales is devolved could affect a judge adjudicating a case in Wales by virtue of being part of the same jurisdiction. And this is actually more likely to happen with the proposed evolution of aspects of criminal, contract and property law. It is very important that we have clear boundaries about what factors judges in Wales look to when deciding cases. This is in the interest of the public. The way to solve this is to recognise, at least with regard to devolved matters, that the law of Wales and the law of England are distinct. Judges deciding cases under Welsh law would not inadvertently affect English law, any more than judges decided cases under English law would inadvertently bind judges in Wales. As the body of Welsh law expands, this will become more, not less, of an issue. It is not hard to solve. The work done in relation to the Welsh Government's draft bill and the analysis of the recent stakeholder group chaired by Mick Antonoff offers a route map here, and importantly, this approach has benefits for both England and Wales. One final point. This bill seems to me to want to give the impression of a distinct jurisdiction, without actually establishing it. The acknowledgement in the opening sections of the bill that a body of Welsh law exists points to that. I believe that we need to take that acknowledgement one step further and introduce in this bill a distinct Welsh jurisdiction.
Dawn